These are not my words. I'm not really comfortable reading these.
A statement of mine was a false memory. It was not a lie.
Dog canines don't move, do they? The defense moves for a mistrial.
It's denied.
There is no dog DNA.
I believe that that's a rather direct impact.
The right rear tail light.
I saw nothing.
Jennifer McCabe and Karen.
Week 7 of Karen Reed's retrial started off with those off-color texts by Michael Proctor, although not out of the mouth of Michael Proctor, and ended up with some new expert testimony.
Is there any hope for Proctor that his texts are going to come off any less cringy and disgusting just because he's not the one reading it this time? I'm Lainey Law.
Well, hi, I'm Andrew Myers.
We got some vile stuff to talk about today.
Yeah, it was a crazy week. It was just a crazy week. And, who knows what's ahead. But Mr. Proctor was never called as he was in trial 1.0 by the state in trial 2.0 in their case in chief. And at this point, as we sit here this second, it looks as though the defense is not going to call him, although that could change. I've heard people say, well, they could change that at the last minute. But what happened is that the defense brought in one of Michael Proctor's old buddies. He and a guy by the name of Jonathan Diamandis have known each other since middle school. The guy has known Proctor for 30 years. And I don't know if you remember way back in trial 1.0 when the vile texts by Mr. Proctor were read. It turns out that not only were Proctor's supervisors and other state police officers listening, but also some of his friends. That there was like a group chat, and some of his friends were in on it. And one of them was this fellow by the name of Jonathan Diamandis. And so he was a very reluctant witness, even more than very reluctant. He didn't want to be there. But so David Yannetti called him to the stand, started asking him questions, and then by some kind of an agreement, Hank Brennan started asking him questions. And that's how these things were brought in. So that is what happened, and that's how they got all these in. And so we're going to hear Mr. Brennan asking Mr. Diamandis some questions.
January 29th, 2022, 11:02 p.m. and 15 seconds. There's a comment from one person in the group, number ending in 5051. Could you read that?
But I assume you guys are out to make it cut and dry since it involves cops.
Next comment by Bird.
Something stinks.
And the comment by Mr. Proctor.
Yeah, but there will be some serious charges brought on the girl.
And the beginning of the next sentence is gotta be. And finally, the last comment on that page.
She hot at least.
And that's a question mark.
Yes.
Turn the page, please. Ending in 3-8. These messages begin at 11:05:57 p.m., run through 11:06:39 p.m. on January 29, 2022. Does it begin with comments from Mr. Proctor?
It does.
Could you read all of them, please?
These are not my words. I'm not really comfortable reading these. Do I have to say these words out loud?
So I'm going to see you at sidebar.
Okay, so they had another one of their interminable sidebars. There have been more sidebars in this trial than I don't know what. And anyhow, after the sidebar, it was apparently agreed to that poor Mr. Diamandis, we don't know him. I was going to say he's an innocent guy, and I presume that he is because he's like, I don't want to read this stuff because I think we all know what's coming from having heard it all in trial 1.0. It's like, I don't want to read this. I mean, he's got 18 jurors looking at him, courtroom full of people, including John O'Keefe's family, his mother, etc. So they came back, and the agreement that they had was he would agree that Hank Brennan was reading these comments verbatim.
Mr. Proctor says, from all accounts, he didn't do a thing wrong. She's a whack job, and then uses the C word to describe. Is that accurate?
That's accurate.
He then says, yeah, she's a babe. Weird
I'm surprised
Fall
he didn't
River
have to say
accent,
it
though.
like Proctor did.
What'd you say?
I'm surprised they're not making him say the C word.
Yeah, because they made Proctor say it. Remember that in the last trial that even Proctor himself didn't want to admit that he said that word, and the judge said, "I want you to say it," and he did. But
Yeah.
I guess Hank Brennan doesn't,
He's
he
not
didn't-
getting a scolding right now.
Yeah. I mean, he's got kids and everything, and he didn't want to say it. But anyhow,
No ass. Are those the words that he wrote?
Those are the words.
And there's a response at the bottom from one member in the group stating, oh, she's skating.
Yes.
Let's turn the page, ending in 3-9. These begin in January 29, 2022, 11:06 p.m., 55 seconds. Is that accurate?
Yes, it is.
Mr. Proctor responds, 0 chance she's skated. She's effed. She's fucked.
Yes,
Is that what he said?
it is.
And then one person in the group says, no ass bitch. Accurate?
Yes, that's accurate.
Mr. Proctor, there's a response, laughed at, quote, no ass bitch. Somebody in the group says, is that chick a smoke? And then the same person follows up with a question mark. Accurate?
Accurate.
Mr. Proctor responds, E-H,
Yes.
nut bag, as my chief would say.
Yes.
She's got a leaky balloon knot,
Yes.
leaks
Oh
poop.
my god.
I never even knew what that meant until this trial, and I had to look it up. So, in any event,
The fact that you had to look it up, it's like, why do these people have these on deck? Like, why are they talking like this? How their mind is twisted to even be there in the first place?
I'm not going to recount my history and my stories about working in the warehouse with, in the loading dock and talking to 18-wheeler drivers all day. And they're nice people, but just imagine how we all talk. You leave that on the loading dock when you go home at the end of the day. And way back then, we didn't have texts, but I don't think I'd be texting my superiors about any of that. But, anyhow, after that recitation of Michael Proctor's fine texts, Judge Cannoni instructed the jury how to consider those texts and that they are relevant only to Michael Proctor's state of mind.
All right, so I've told you folks previously, but I've got an additional instruction here. And I think so you know this, and you'll hear it at the end of the case as well. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the person who authored or created or transmitted the communication was in fact the person alleged. And here we've heard it be Michael Proctor and high school friends, the testimony was, I believe. If you do not find it is more likely true than not that the person alleged to have created or sent these messages, then you may not consider the electronic communication in deciding this case. And also here, this text message chain was not being admitted for the truth of what's in the chain, but
No, really? I mean, those things weren't true that he said about her? Oh, really?
I just want to know where all these jury rules were when they were supposed to be deciding the verdict. She's got all these stipulations right now, but here we are on trial too, where it wasn't clear enough for these people to come on agreement of the two charges and present that.
Yeah, you gotta wonder if they remember the texts and the profanity or the judge's instructions.
solely for the limited purpose of weighing the texts as they go to Michael Proctor's state of mind, and more specifically, whether or not that state of mind reflects any bias or omissions in the police investigations.
And so it's kind of a little bit of justice that the Commonwealth was a little bit chicken shy of not putting Mr. Proctor on the stand, but, then Hank Brennan had to read those words himself. So that was a little bit of justice. As Lenny Bruce used to say, in the halls of justice, the only justice is in the halls. Well, this time the justice was at the Commonwealth's bench. So
I do want to say, for anybody who's watching right now, if you've made it this far in the video, consider liking the video, leaving a comment down below, perhaps with a palm tree to celebrate summer, and subscribe to our channel if you're not subscribed already. We do talk about the Karen Reed case every week at this point as the trial's going on. We try to give like a little recap of what's going on.
Yeah, thank you. We don't sell mugs or T-shirts or aprons or, do commercials for skin cream or financial brokers. You can find a financial broker on your own. You don't need us. So it's free. Just go down to the bottom there and click the little subscribe. Thank you. So, oh my gosh, I don't know how to even mention former Canton police officer Kelly Dever. Don't you dare mispronounce it and say Dever. She will blow a gasket.
Oh, don't tell our commenters this. I'm gonna butcher it, and you're gonna butcher it at some point. We're gonna get massacred in the comments.
Dever rhymes with never, and she never should have said what she said when she went to the FBI on August 9th of 2023. And what she said then was she had gone down or at least seen former Canton Police Chief Kevin Berkowitz and Brian Higgins go into the Sally Port, and they spent what I believe she said was a wild period of time in that Sally Port where Karen Reed's Lexus was parked. And now she has recanted all of that. She recanted it and called it a false memory.
Did you observe anything unusual that stood out in your mind that occurred, pardon me, in the Sally Port while you were on that shift?
So we've discussed this previously. I can't make that statement on the stand because I've been provided information released by the defense that it was not a memory, that it was a distorted memory. Therefore, I can't state it because at this point it would be a lie. I cannot make that statement that you're wanting me to make on the stand because I've advised that that would be a lie.
Ms. Dever, I've never asked you to make a statement one way or the other on the stand. I'm asking you an open-ended question.
Okay,
Did
so
you,
prior to
let
the
me ask
first
the question. Did you observe something in the Sallyport garage on January 29th, 2022 that you found unusual, that stuck out in your mind?
Given factual information,
Did it look like she was about ready to cry there? To me, it looked like she was about ready to break into tears, and then she pulled herself together.
She is really trying to not say something. I don't know. It is one of the things, because I've been following, this is my tangents. Thank you, commenters who complain about our personal stories. But I've been watching Rotten Mango's commentary on the Diddy case. And one of the things that she was saying about the witnesses is that a lot of them seemed authentic. There's something about the Karen Reed case where everyone on law enforcement seems inauthentic. It seems like they're trying to pause and think and stop themselves and be very controlled. And it icks me.
Well, the backstory here is that between the time that she testified to the grand jury or to the FBI and now her testimony here where she's recanting, she had worked for the Canton Police Department and now she works for the Boston Police Department. And she had been called into the commissioner's office, and apparently, even though she denies it, apparently the Boston Police Commissioner had said, do the right thing. And subsequent to that, what she did do was recant her previous testimony.
that makes it so I know I did not. No.
So the answer is no.
Correct.
Do you remember being interviewed on August 9th, 2023?
I do.
That was by a separate law enforcement agency, correct?
Yes.
Two separate law enforcement agents, is that right?
Yes.
And you were advised during the course of that interview on August 29th of something, correct?
Can you rephrase
I'm sorry,
that?
August 9th.
So what was I advised of? Can you rephrase that?
Sure. Were you advised that lying to those officers would be a crime?
So it was a willing conversation. I've spoken with their legal team. Because of the fact I was providing factual information that showed a statement of mine was a false memory, it was not a lie. Therefore, I made it in good faith, and I retracted given information that it could not be accurate.
That wasn't the answer to the question, though. She was not answering the question that was asked of her. She was asked whether she was advised by the FBI people. Remind people why we're not allowed to say FBI, but she went to the FBI and she spoke to them. And at one point in her testimony, she said, no, she had never been advised that stating a mistruth to these agents that she spoke to was a criminal offense. So we knew right there that there was something off, because that's what FBI agents always do before you talk to them. They always, give you a little colloquy. And one of the things they tell you is, you don't lie to us because you will be criminally prosecuted. I just want to remind our viewers that we went more in depth. That's the only video cut we're going to show you of Kelly Dever, because I did a whole kind of episode on her and went more deep in depth in a previous episode, and I'll link that down below in the comments section. So then we come to Dr. Marie Russell. We all know about Dr. Marie Russell because, anybody that's followed this case has seen her a number of times. She testified in the first trial, and then she was called to a voir dire, even though Judge Cannoni would not allow voir dires of other expert witnesses. There was an extensive, 2 whole days of voir dire of Dr. Russell, who says those injuries on John O'Keefe's arm are very obviously caused by a dog bite or a claw mark. And Hank Brennan went on and on and on cross-examining her. But I think a lot of our commenters, many of our commenters have said that's just so obviously a dog bite. Not only a couple of kids who have been bitten by dogs, but some people that do have medical backgrounds. I think we had a nurse in our comment section say, I've been a nurse for X number of years, and those are so obviously dog bites that in any event, Dr. Russell, our viewers know, was voir dired twice, once in December of 2024, and then once again right after the holidays in January this year. And she came once again and testified that those injuries to John O'Keefe's arm were from a dog, but Special Prosecutor Hank Brennan cross-examined, getting into the different types of teeth, incisors or canines, and he went into a bunch of other deep intricacies about dog bites.
Look at the spacing, Dr. Russell.
Did you say strike or strike?
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds. The canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
I would have objected to that because that requires expert testimony, and his expert would have had to have been there to have said that. So I would have objected.
They don't,
Yeah,
and
he's
I'm
not
not claiming that these 2 parallel stripes in this case, or abrasions here, I'm not claiming that those 2 were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the
exactly
arm?
what I'm asking. It's a question I've asked before. When you look at the other
think so
side of
long
Mr.
for a
O'Keefe's
tail
arm,
light.
did you notice any?
I'm sorry, what'd you say?
I said it's so long for a tail light. It's like, how big is? I can't even have the size of this arm in the camera for it. How big are I guess I can see a tail light being kind of like that, but I don't know. It's just looking. I hate looking at that picture, and then looking at that picture just makes me even more confused.
Yeah, well, you asked about the tail light. Oh, we'll get to the tail light. Never you mind. We'll get to the tail light and the new experts, the ARCA experts. But let's finish up with Mr. Brennan trying to score points with Dr. Russell, who was in the Los Angeles emergency room for years and years and years.
Anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog, it's like a lever, a dog's mouth, isn't it?
It can be if both jaws strike the skin. However, There are many times when only the upper jaw strikes the skin.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, the prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA. Under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it, she discounted it, she created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed for this jury yesterday, but it is not improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog.
A dog. Did you hear that inflection there?
And just like the whole thing is so annoying because, you know, obvious there's issues with the DNA stuff too, but it's like saying because there is no DNA, it is factually not that. And I don't think something being omitted is necessarily factual evidence. The not presence of something, I don't know. It's just, he just sounds like a jerk.
Well, the substantive constitutional issue that the defense team for Canton and Reed was, in my view, properly raising was that, the Commonwealth made a decision that they were not going to bring their DNA expert in. So instead of, putting a witness on the stand, they came in through the back garage door and said during cross-examination, well, doesn't the fact that there's no DNA on John O'Keefe's arm, doesn't that tell you that he wasn't bit by a dog? And it's just, that's when the defense objected, and they brought this motion for a mistrial. And guess which way the judge ruled on it?
Well, I was going to say, unfortunately, dear viewers, we're still here right now talking about it. In case you haven't noticed, the video does not directly end here. So a little bit of a spoiler alert.
No. Although they're saying that the trial may end early in week 8. So we still have to get through week 7. This trial is going very differently from the first trial. On Wednesday, right in the middle of week 7, the weather forecast was for a very, very, very hot day on Thursday. And also Judge Cannoni told the jurors, we're ahead of schedule. So because of the fact they were ahead of schedule, and because the fans and the AC in that little old tiny courtroom are so loud, they decided to give the jury the day off on Thursday and then come back for Friday. But anyhow,
feels like middle school or high school.
Yeah, I don't know.
It's like you guys could be free.
My high school was a brand new state-of-the-art building. Yeah, we had great air conditioning. But anyhow, do you remember prosecution witness Judson Welcher? He was one of their experts, and he dressed up like John O'Keefe and painted blue grease paint on the exemplar Lexus. Remember that?
Oh, I wish I could erase it from my mind.
Oh, good grief. So defense attorney Robert Alessi asked Dr. Russell while she was still on the stand, wouldn't that impact have broken bones?
So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm.
I just want to pause this and say this is stressing me out because, like she said with the picture, it's a direct impact. That's the best that they're going to be able to get, where it's like his arm has to be fully in front of the tail light. But also I'm just thinking about how ridiculous it is. I just imagine like the comedic explosion of this for the lacerations. Anyway, just the thought of that was
it makes no sense.
Yeah.
I mean, for the Judson Welcher testimony to make any sense, we have to know what position was John O'Keefe's arm as he was walking or standing or doing whatever he was doing at the alleged moment that purportedly Karen Reed's Lexus backed into him. And we don't know that. You don't walk like that. I mean, unless you're playing Superman. So the whole thing kind of fell apart, but I think that Dr. Russell answered the question fairly well.
Experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Good answer. I thought a big Lexus SUV, it's 6,000 pounds, backs into you. How does it back into you and you don't break anything? It just, I don't know, doesn't make any sense.
Even beyond that, it's just Like, even with the arm thing, I'm just sitting here thinking about how much my professors would love turning this into some type of math problem or statistics problem, because in my head I'm just sitting here like it has to hit at this angle at the acceleration of speed to break the glass that has this level of resistance to kinetic force, and even just the probability that his arm was in the exact same spot as in that picture to even be able to do that. There's just so many variables where this all just feels like an inefficient way to go about this. And it also feels like I gotta make sure that my professors don't see this, because there's more, I feel like there's more scientific ways to go about this.
Yeah, I think so too. But we're going to see some of that when we get the defense experts, the ARCA experts back on the stand, because there's new experimentation that they did. But another key thing that came out in week 7 was testimony of Dighton Police Sergeant Nicholas Barros. This is key because when the investigators caught wind of the fact that Karen had gone down to her parents' house down in Dighton, Massachusetts, they sent a flatbed truck down there to get it and bring it back. And so when they went to Dighton, they notified the Dighton police, and Officer Barros was there. He's now a sergeant in the Dighton police, and he went on the stand, a police officer called by the defense, and he said that in his observation, there was in fact some damage to that taillight, but it was nowhere near as substantive and huge as the pictures that the jury had been shown.
I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that
Yep.
description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
Does not sound
When
like
you
it
say there was
exploded
a
and
crack,
shredded
you mean
his
there was a
arm.
piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you would call it?
The piece was about maybe this big,
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere
Okay.
in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear taillight,
Of what?
the Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the taillight the day I was there.
Can you do me a favor, Mr. Wolfe? With the court's permission, could we zoom in on the right rear taillight, please?
Okay.
Do you see the condition of that taillight as it's depicted in this photo?
I do.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
So what's important here is a police officer that is testifying about the police work in another town and saying that what they're saying on the stand to this jury is wrong. And that's significant. Two things significant about this. One, there's a police officer here who is saying, what these officers, what this law enforcement is trying to tell the jury is wrong. And two, he's able to substantively point with his pointer that what he saw was not what was shown to the jury. So that is extremely important.
Damning. It's terrible. It's adds to the skin crawling nature of all of this. It's like you take in mind all the horrible things that Proctor has done independently. Higgins, I was talking about for like 5 minutes the other day, just pissed off. But it's just like that, all of that on top of this guy saying that what they're using as evidence isn't even what he saw after the accident.
And so now that we're talking about, the police investigation and, the many things we've talked about before, the leaf blower, the solo cups, not isolating the crime scene, not separating the witnesses, all of those things led in week 7 to the defense bringing a motion to reconsider the judge's denial of allowing their expert, Michael Easter from the FBI, who was proposed to testify as to proper crime scene, proper processing of a crime scene. So they filed a motion saying that here are the things that went wrong, and here is why we should have a reconsideration. So usually motions to reconsider are not favored by courts, and you have to find some new grounds to justify your bringing a motion to reconsider. Well, here's the motion to reconsider in this case. As you know, the FBI guy, Michael Easter, who was going to testify as a expert in crime scene evaluation, the judge said, no, can't have him. Well, here's the defendant's motion for reconsideration of the March 31st order, excluding the testimony of defense expert Michael Easter. What is new, you ask? Well, what has come out during this trial and why the defense says that now at this time there should be an expert on crime scene evaluation. Recent trial testimony has materially altered the posture of this evidentiary issue. Lieutenant Paul Gallagher and Trooper Yoli Buchanan each testified to conduct which clearly deviated from standard law enforcement protocols, but refused to concede any wrongdoing. Over the course of 2 days on May 5th and 6th of 2025, Lieutenant Gallagher testified to his account regarding evidence collection outside of 34 Fairview Road. Lieutenant Gallagher stated that he used a leaf blower, yes, the famous leaf blower, to clear the area and uncover crime scene evidence, a method ripe with a substantial risk of disrupting or destroying evidence. He said it was proper and effective in this instance. Further, he testified that because of the weather, it simply would not have been impossible to follow protocols. Finally, Lieutenant Gallagher admitted that he chose not to search the home adjacent to the crime scene owned by a fellow officer, falsely claiming lack of probable cause and that it would be improper for him to attempt to obtain consent, which is, in my view, just totally backwards.
I would
Because
let someone know at least that there's a body outside their house.
I mean, if you find a body outside the house, yes, you do have probable cause to either go inside or get a search warrant. I doubt if there's an okay judge in the entire country that wouldn't grant a search warrant. I mean, it's ridiculous. That testimony was incredibly misleading, and there is a significant risk that jurors will give his testimony undue weight merely because he is law enforcement and lay witnesses are unfamiliar with the legal standards attendant to criminal cases. And then we get to Trooper Yoli Buchanan, who testified over the course of 3 days on May 8th, 9th, and 12th regarding his involvement in the investigation, and asserted that his investigation was conducted with honesty and integrity. The defense is entitled to rebut his self-serving claims. Trooper Buchanan admitted that he never entered the house at 34 Fairview Road to search for evidence, interview witnesses, or to photograph the home at 34 Fairview Road on January 29th, 2022. Furthermore, Trooper Buchanan failed to explain the divergence from the normal chain of custody protocol, noting that while certain evidence was discovered on February 3rd, 4th, and 10th of 2022, it was not written in a report until November 4th of 2023, a year and a half later. I mean, tell me that that's something that's normal.
Disaster. Well, how do you? I can't even. If you told me to write a report on something that happened a month ago, I would fail you. Like how? Oh my God.
It's just, and these are grounds that should allow a court to reconsider its previous erroneous ruling. And we get back to Mr. Buchanan failing to offer an explanation for failing to interview two potential witnesses, Ricky D'Antonio and Heather Maxson, who were at 34 Fairview Road until over a year later. Furthermore, Trooper Buchanan admitted that there was evidence logged that he himself turned over where he could not identify who eventually filled out the evidence label. He claimed that there was nothing unusual with the handling of the evidence in this case. Proper chain of custody protocols are not common sense issues that are apparent to laypersons. The defendant is entitled to call an expert witness to testify regarding proper chain of custody evidence. Guess what the judge did with this? Denied. There was no, at least as of the moment that we are recording this podcast, nothing written, no indication until at the end of one of the days of testimony after the jury was out of the room. And she asked, does anybody need anything from me? The defense said, yes, what about our outstanding motion? And she said, no, it was denied.
Ridiculous.
And held her hand up like this. So, a lot of crazy things in this case, And
is the assumption that they're supposed to take the police officer at his word, or that they're just inherently so knowledgeable that they don't need to be explained that things were improper? Because with her, I don't know. I just think it's ridiculous to just not allow them to make that argument, to not bring in an expert, because it is a mess. It was done improperly. You should not be using red Solo cups, at least in my opinion. If we had an expert to explain that to us, maybe I would feel different if they said red Solo cups were okay.
I guess what the judge is implying that, the jurors have common sense and they can figure out what is a proper procedure. A kid that watches CSI knows that evidence has to be handled properly. And I don't agree with that at all, because, the thing is that an expert should be allowed under the rules anytime the expert has knowledge that's above the norm, and anytime that the testimony they would offer would be both relevant and helpful to the jury. And so I would think it's definitely relevant and helpful to the jury. Let's get back to the witnesses. One of our favorite witnesses, I think, is Lucky. Lucky is a Canton snowplow driver by the name of Brian Lawfren. He had key defense testimony because he was plowing Fairview Road the night of January 28th and 29th, and he went by the house and he never saw a body lying on the front lawn, which is what the Commonwealth alleges would have been there.
Now, as you were passing 34 Fairview, could you see the area of the flagpole at 2:45 in the morning, sir?
Yes.
What was on the ground on the Alberts lawn at that point in the area of the flagpole?
Nothing.
Did you see a 6'1", 216-pound man lying on that lawn?
No.
And when you're coming back down, what side of the road is 34 Fairview?
On my left.
When you pass 34 Fairview at that time, are there any obstructions preventing you from seeing the front lawn?
None.
Was there any difference in the lighting on your truck when you were coming back down?
No.
Where is your attention focused when you're passing 34 Fairview on your left?
Again, out the front, right and left.
And how much of that front lawn are you able to see on 34 Fairview when you're coming back down from Chapman?
I can see everything. I can see right up to the front door.
What did you see on the front lawn of 34 Fairview on January 29th of 2022 when you're making the second pass by 34 Fairview in the area of the flagpole?
I saw nothing.
I want to say this is also notable too, because when you're driving, especially in New England, a lot of people can empathize with this. You're watching out for things too that are going to be on the side of the road that can jump off, whether it's like deer or raccoons or possums. Like when you're driving in the dark, your eyes are very alert because there are a lot of things that can also be jumping out at you.
Yeah, one of the things that I left out, I mean, there's just so much. We're trying to cover a whole week, in one brief episode. One of the things I left out is that Lucky is driving this huge snowplow. They call it Frankenplow because it's huge. It's got parts, all put together, but he's way high off the road and he's got lights all over the place. And, he can see the yards on both sides. He's looking for anything like a dog to run out in front of the thing. He can see the flagpole. He can see up to the front, so this thing is huge. It's got a lot. It's lit up like a Christmas tree. So for him to testify that there was nothing on the front lawn, it's big testimony.
Now, you take the right onto Fairview. Describe for the jury what you see in the road at that point.
As I make my right onto Fairview, I notice that there's a vehicle on the right-hand side, roughly in the area of the flagpole, in front of 34 Fairview.
Okay. And did you make note of what type of vehicle that was?
Yes,
What type of vehicle was that?
a Ford Edge.
Was it parked adjacent to the Albert property, or was it across the street from the Albert property?
Adjacent to the Albert family.
And how close to the area of the flagpole was that Ford Edge parked at 3:30 in the morning?
I can't give you an exact measurement, but looking at the front door, it was about 3 feet to the left of the front door in the area of the flagpole, so in between the front door and the flagpole.
Okay, then on cross-examination, Special Prosecutor Hank Brennan attempted to allege that Lucky, the plow driver, had been intimidated into his testimony by blogger Turtle Boy, although not using that name in open court.
During the pendency from that night until today, it's fair to say there are many times where you have been intimidated, isn't it?
No.
You've been threatened.
Nope.
You were aware, sir, that you were being threatened by an online blogger to expose you?
I was not.
Yeah, so he's trying to say that Turtle Boy, who, by the way, just reached 100,000 subscribers on his YouTube channel, so congratulations to Aiden Carney for that. Anyhow, Mr. Brennan is trying to allege that somehow Mr. Carney, Turtle Boy, intimidated him into... Now, I don't know about you, but look at this guy. Does this guy look like a guy could really be intimidated?
You're saying as you sit here today, you have no awareness in the history of this case that you were being threatened by an online blogger?
I was not threatened by an online blogger.
Was the online blogger...
My question is, Aiden there in the courtroom right now?
Yes.
Okay. Because I know it was like the back and forth.
Yes.
Is he going to be a witness right now?
Yes.
But it's just like, I wish that we could see his face right now as they're like, were you threatened, intimidated by him? I'd be laughing.
There is a picture, and if I can find the picture, one of the newspapers did that. He was wearing a red shirt, and he was making a face like... If I can find it, I will, in post-production, I'll find that and edit it over here. But yeah, it goes by week and it goes by lottery, but this was Mr. Carney's week to be in the courtroom, and so there he was, and watching all this craziness.
or threatening or saying that he would expose you and tell personal things about you if you weren't helpful?
He was not threatening.
Let's remove the word threatening. Was the person communicating and making clear to you that if you didn't testify in a certain way, there would be some consequence to you.
Objection. Can we have a time frame, please?
Anytime from when you first spoke to the private investigator until today, were there communications made to you by an online blogger that there would be consequence for you if you didn't testify in a way that was acceptable to them?
No,
You listened, of course, didn't you, to podcasts that were about you?
I did not.
People told you about them.
Yes, they did.
When friends told you about them, you knew who that person was that was making those claims, correct?
Correct.
You were well aware of the person had a very strong and large social media presence.
I didn't know how large or what his presence were, but yes, I knew he had a blog.
Well, you know
I
now
would
that
say
you
subjective,
follow
yeah.
that blogger now, don't you?
I do follow him, yes.
Do you pay for a subscription?
I do not.
Did you get
Hank, my friend, you don't have to pay for a subscription, which reminds me to ask our viewers right now, we don't sell mugs, we don't sell T-shirts, we don't sell hoodies. All we do is to ask you to give us a subscription. As Mr. Brennan doesn't know, it's free.
And help us get to that 100,000.
Yeah, we're way behind him, way behind.
We
but
got a
we're-
quintuple.
We're getting
free?
I did not.
And in following that blogger, you know full well the power that person has to get attention from the community to harass, correct?
Yes.
He said he didn't watch.
Okay. All right. So the
That was
last
a
witness,
disaster.
the last witness we're looking at on week 7 is a young lady by the name of Karina Kolakaitis. She brings the focus that we had watching this back to the night before, the night of January 28th, 29th, in the Waterfall Bar, where she testified as to her observations when things ended. She thinks it was right around midnight.
When you were leaving the establishment, whom did you leave with?
So again, it was myself, Jennifer McCabe, and Karen.
Did anything unusual occur when you were leaving?
So as we were leaving, Jen went over to Karen, kind of put her arm around her, and she started saying, "You're coming with me, you're coming with me." And Karen's like, "Huh? Like, what? Like, where are we going?" And
I'm going to sustain the objection.
The first part of that answer, the putting her arm around her, "You're coming with me," why did that stand out in your memory?
just because I was there too, and it just was strange. It was just like, "You're coming with me." Like, it was just something that stood out to me.
You weren't included.
I mean, no, it's fine. I mean, it was just stood out, you know? Yeah.
Did Karen go with Jen McCabe?
No, she did not.
What did you see her do?
So then, out of the clear blue, thinking that Karen was going to go with Jen, I see Karen with John.
And where did you see Karen with John?
I saw them just I was parked across Washington Street, across from the restaurant, and I just saw Karen and John like walking down towards what used to be Amber Road, a place.
It used to be Amber Road?
It used to be Amber Road, yeah.
Is that a Amber Road cafe?
Correct. It was like a it was like a little cafe shop.
And did you figure out why they were walking in that direction?
That's where I think Karen had parked her car.
Did you have any concerns about Karen being able to drive that night?
I had talked to her all night, and I did not notice anything strange about her. Like, I didn't think anything of it.
Interestingly enough, Karina also, who was there with her husband, said that she noticed during the night that John O'Keefe and Karen Reed seemed to be lovey-dovey. They seemed to be, doing pretty well with themselves, and that there was no reason to really suspect that there was animosity between them. No real motive, if we need a motive here.
No reason to suspect that she was going to go commit vehicular homicide in a few hours.
Exactly. So you remember we were just talking about the motion for reconsideration. Well, here at the very end of the third day of the week, right before they took a day off, here is how the judge notified the parties that she had denied that motion for reconsideration to allow the expert Michael Easter to come in and instruct the jury about, how crime scene investigations are supposed to go. It was kind of offhanded. Watch this.
Is there anything anybody needs to raise with me at this point?
No, Your Honor.
Okay.
There is one outstanding motion, it's a motion for reconsideration.
It's denied.
Look at that. Denied. My granddaughter, when she was 3, if she didn't want to do something and you told her or asked her, she'd go, whatever. It's kind of like the same thing. Now, I think by the time she was 5, she stopped doing that.
Denied.
Denied. Whatever. So I don't know. That's, it's not a good look for the Commonwealth. I mean, as I pointed out a few minutes ago in this podcast, the defense team took the time to write a motion that was that long, and it documented some facts that came out during the trial, and I believe they had good grounds. Now, it is true that motions for reconsideration are not often granted because generally they ask the court to admit that they were wrong. But in this case, that wasn't true because there was new evidence of new things that were testified to by Lieutenant Gallagher and by Buchanan. And I don't know. In my mind, I'm sure people might disagree with me. They do all the time. But in my mind, that's reversible error, not to allow the defense to have a legitimate expert, been with the FBI for years, knows how crime scenes are supposed to be evaluated, and probably would have blown this case out of the water. In my view, that's my opinion. But, I think that he would have blown this case out of the water. No.
Yeah, I don't know. I think I obviously don't have experience trying to get specific witnesses on trial, but I would assume that if anything, this guy was relevant. I mean, especially considering how many headlines and everything we have of how this was conducted in the first place.
Yeah, so now the week closed out with the testimony of Dr. Daniel Wolfe, the long-awaited ARCA experts. And he went through a very great deal of testing that had been done.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject 2021 Lexus is consistent with an impact to John O'Keefe's right arm during a high-speed reversing maneuver?
Sustained in that form, Mr. Jackson.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject vehicle is consistent or inconsistent with an impact to a right arm during a high-speed reversing maneuver?
It was inconsistent.
What's the basis for that opinion?
All of the test data that we did from the laboratory testing, moving up to full-scale vehicle testing, all of the collected data in terms of the photographs, the observations, all of the acceleration data collected. So all of the testing that we've walked through in this PowerPoint, along with certainly that was based upon all generally accepted and peer-reviewed methodologies in the accident reconstruction community.
Do you hold that opinion to a reasonable degree of scientific certainty based on your experience, training, and education?
Yes.
Did you reach any opinions or conclusions as to relating to the punctures, holes in the hoodie that you saw that was related to John O'Keefe?
Yes.
Do you have an opinion or conclusion as to whether or not the damage that you saw to the hoodie related to John O'Keefe is consistent or inconsistent with a impact from a right rear taillight of the subject SUV?
It was inconsistent.
Okay, and so that was Daniel Wolfe of ARCA testifying that they had done an exhaustive amount of testing. In addition to what they'd done before, they took a look at Judson Welcher, the Commonwealth's expert, and what he had done, and just kind of blown the water out of that. So we'll let our commenters decide. When there's two experts, it can go either way. So we had a lot of comments on our last episode, the episode on Kelly Dever. A lot of comments.
So starting off with this comment from Doom 4067. Assuming that her brain truly creates false memories out of thin air, that alone could disqualify her from being a cop. It was crazy. That was the most bizarre thing, and mix of trying to have a straight face while going through all those emotions. That was bizarre.
9 from Julia Sugarbaker. You popped up on my feed today, so this is my first vid of yours. Just wanted to offer some positive feedback. I appreciated your take, and I respect the way you handled the criticism from your subscriber. Thank you for spreading kindness and professionalism in spaces where it is not always present. Well, thank you, Julia. We're glad the algorithm pushed us into your computer or laptop or whatever device you saw us on. So thanks for letting us know.
All right. So from White Great Snow, I have a serious problem with this convenient answer of I don't recall. It amazes me how good their memory is when they're testifying against someone, but how faulty their memory becomes when it's harmful to themselves or others they're protecting, and it's a disaster.
Funny thing about that, isn't it? Okay, Gossip Goat. Welcher's 2-mile-an-hour simulation for an alleged 24-mile-an-hour vehicle strike was akin to testing a gunshot wound by throwing a bullet, statistics testing, and then saying the marks made were the same. Asinine. He didn't even consider other possibilities, which puts his confirmation bias on full display. He seemed more like a pay-to-play expert than a neutral expert, just reporting on their unbiased testing and info like Dr. Russell did, who considered every possibility within reason of what could have caused John's injuries. Welcher could learn a thing or two from Dr. Russell, mainly integrity, which would do wonders for his credibility.
Yeah, no, the thing is, it's just like mainly integrity. It just, a lot of the times with the state, it just seems like a lot of the people they're choosing to put on are maybe overcoached. It seems strange. Shush Now 3812. Surprised she didn't use the word nefarious.
Nefarious.
A legend McCabe rather than malicious.
I don't know. 5. T-Rex says, when she says, I don't recall that, she looks down and grins like she got away with something. Also, how does someone so young almost double her salary in 3 years?
Hit me with that. I'll take it.
Dun, dun, dun.
Dark Beach 72. Have you noticed that Brennan keeps trying to gaslight witnesses into thinking they've changed their testimony when they haven't? I've never seen a lawyer do that. Were you threatened? No. Did you get threatened by this YouTuber? No. I've never seen a lawyer do that. He acts like he's about to impeach them with prior statements, but he's lying about the prior statements to just bait them into changing their statement. Slimy as hell. He's a bad guy.
Okay, Marley Beans. Is it unusual to change your statement with the FBI in an unalived case? Or more so, would the FBI accept a redaction? In my opinion, she was changing her statement on the stand because of threats from the real unalivers. She was awful, rude, and not credible. Didn't do her fellow law enforcement officers any favors. KR has been framed. Well, as to the first question up top here, is it unusual to change your statement with the FBI in an unalived case? Well, it does happen, but, it is unusual. Would the FBI accept a redaction? Well, her story was that she didn't lie because the statements that she made through her false memory, I don't know what that is really.
I forget things. Seldom do I have false memories, that. I can't remember a time.
Clearly there was something more involved. So she says what she stated, and we don't know what actually happened, but she stated that she talked to the FBI's legal team, and they said she wouldn't be in trouble because at the time she made the statement, it was made in good faith.
I wish I could talk to the FBI legal team when I have an issue. That would be great.
I wouldn't talk to the FBI ever. I would never, and I would advise anybody and everybody who's listening to us, if the FBI ever comes knocking, you have the right under the Fifth Amendment to say nothing and call a lawyer immediately.
Yeah, if they want me, I don't want to talk to them. If I want them for whatever reason, having a direct line would be great. All right. So this one is from Darda Gano-Hara 9190. If you watch the Sally Port video, a woman walks into the room, turns around and leaves. That was Kelly Dever, I'm sure. We never see anyone say who she was, but I'm sure we can now figure it out. She's seeing them smashing the taillight, I bet. Now she goes from 80K to 140K promotion and moved to the Boston Police Department. Yeah. Then do the right thing because your blue wall of silence got cut off, but we can interpret what they were trying to say with that.
Whoever did this slide is fired.
Yeah.
Out of here.
Aw.
Number 1, Brenda Winters. Mad Dog, I don't think you were here for the last episode that we did. Mad Dog had criticized me for being biased, and I took the opportunity to say, no.
Isn't Mad Dog also someone who's commented a decent amount? So I'm surprised what irked them. But
no, Mad Dog, if I remember correctly, had said that he had always liked our podcast because we were fair, but more lately I'm getting biased. Well, guess what? More lately, my mind is opened up to what's really going on in this case. And I will say what I say. I will say what I think, because you know what? If you start, making things up or pretending to be somebody that you're not, that's when you run into real trouble. So what I had said to Mad Dog then, and unfortunately, putting myself in the position of repeating it, I will state what I think. Okay,
Yeah.
That's just the way it is.
Well, and people have asked me too, separate outside of the podcast, what I think of the Karen Reed case. And I always say it's just like, I feel like you can't really prove to me that she was hit, but you can prove to me that if she's going to be on trial for this, that all these other cops who were drunk driving around town need to also be put on trial. There's a bunch of other issues that aren't related to Karen Reed in this case. So if it sounds like we're being biased, I mean, Andrew has his own separate opinions. I have mine, but the whole case is annoying. So I am a little biased in the sense that I think this is ridiculous.
So let's finish this up from Brenda Winters. Thank you. We have seen enough people in this trial who pay no attention to the laws of justice and the scientific facts. You are among the top-notch attorneys, including here in Canada, who have followed this trial for the past 2 years and are well-informed and speak the truth based on the facts. Keep up the great work, Andrew. Thank you. And now, I love that picture of Robert Alessi. I forget who I was talking to about him. And in addition to the fact that we know he was a pharmacist, and we know he's a New York attorney, and we know that he's an excellent person when it comes to digging into what experts really have done. The person I was talking to, does he have a musical background? Look how he always, the way he uses his arms, he just doesn't wave them around like some of us, but it almost looks like he's conducting an orchestra. So if any of our viewers know, does Mr. Alessi have any kind of a musical background? That would be good to know.
He's conducting the court.
Yeah. So yes, now we have 72 countries that have had comments to us. And so we could go for more, but at this time we have heard from people in 72 countries and every single United States. We have gotten comments from people in all 50 states, the District of Columbia, Puerto Rico, and Guam. So if you are in a country that's, not on that list, let us know. So that's the end of week 7. It was quite a week. I think the defense did a good job. I think that they are putting on more witnesses than they did last time. Lucky Loughran was a great witness. The Dighton police officer added quite a bit. So I think it was a good week for them. It was a good week for them. I don't know. A question that I would have for our viewers as we end this episode, a question that I would have for our viewers is, does it really make any difference about Proctor's texts and what he said? What are your closing thoughts?
I mean, I want to start off my closing thoughts with Once again, like I said, let's get to that 100,000 as we speed past 20,000. Thank you, everybody who helped us get there. Be sure to like, comment, and subscribe. We appreciate your support. But my other thought was, you mentioned that we can't say FBI during.
Oh, yeah.
Yeah. So what is that all about?
Well, that's a mystery, and hopefully we'll address that in our next episode, because the judge did say during this trial we will not talk about the FBI. We won't mention the FBI. Anytime it comes up, we will talk about that other law enforcement agency that's not the Commonwealth, and that's not Canton, and that's not the Mass State Police. So the real question is, don't you think the jurors are smart enough to figure that out? I mean, don't you think the jurors, using their common sense, which they're implored in the final jury instructions, don't you think they'll kind of figure that out, especially now that Kelly Devers, I'm being really careful to not pronounce it the other way, she talked about going to the FBI. So she brought it up. It's out there. Whether the jurors put 2 and 2 together, yeah. So
yeah, I mean, I want to say shout out to the defense and all of my bias, because the rules and jump ropes that they're going to have to jump, that they've been jumping over and that they've been accomplishing, they've been doing it pretty gracefully. And I give so much credit to attorneys who deal with this kind of stuff, because geez Louise.
Okay, last time I made up the emoji and I said, let's have police cars or cars, and we got some cars. So what's the emoji this week?
I want to see palm trees, I want to see ocean waves, and I want to see sunshine. I want us to start having a nice hot summer. Tell me any beach stories. Do you live near a beach? Do you live in the middle of the United States and you haven't seen a beach in your whole life? I want to hear all of it in the comments down below.
Thank you. Time for the grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.